Mr. Zulu was rational, with or without res judicata. Now, we deal firstly with the rationality based on res judicata. We submit that the identification of His Majesty King Mr. Zulu took place on the 14th of May 2021. This identification, we submit, was the subject of full litigation before Justice Madondo in the KwaZulu-Natal Division, Pietermaritzburg. Judge Madondo found that the identification process complied with Zulu customary law. And that judgment of Madondo AJP was neither appealed against nor set aside. It's therefore, we submit, binding and final. And this judgment is to be found in Volume 1, pages 124 to page 167. We submit that the Court Accord correctly acknowledged this legal bar. And in this regard, we refer to the judgment in Volume 25, on page 4785, paragraph 31 and 32, on page 4787, paragraph 35, and page 4784, paragraph 36, page 4796, paragraph 61. Although the Court correctly acknowledged this legal bar, the Court inconsistently proceeded to grant relief that undermines the binding nature of that finding. And here we refer to Volume 25, page 4798, paragraph 2, 4794, paragraph 64. We therefore submit that the Court erred in reviewing the recognition decision, despite the recognition being premised on that same validated identification. We also submit that issue estoppel applies here. And for that submission, we rely on three authorities. The judgment of Smith versus Porritt, to which we have referred in our heads. Judgment of Caesar Stone, to which we have also referred, and the case of Royal AM Football Club. These authorities confirm that issue estoppel applies even where causes of action differ, provided the central issue is the same. And we submit that the central issue in both matters was and remains this: was King Mr. Zulu validly identified in accordance with Zulu custom? And we find this in Justice Madondo's judgment, Volume 1, page 43, paragraph 46, page 145, paragraph 51, page 146, paragraph 55, page 147, paragraph 58, page 149, paragraph 63, page 152, paragraph 75, page 153, paragraph 78, page 154, paragraph 80, page 159, paragraph 92, page 160, paragraph 93 and 94, page 161, paragraph 95, page 161, paragraph 96, page 162, paragraph 98, 163, paragraph 94, 163, paragraph 99, 164, paragraph 101, and we rely particularly on page 164, paragraph 101 for the issue relating to the application of Section 8, subsection 4 of the Traditional Act. And paragraph 165, page 165, paragraph 103. We submit that that issue has been finally decided and cannot be re-litigated because there was an appeal that lapsed because it was not prosecuted. We submit that that finding by the Court of Quo should have brought the matter to a close, and that the President cannot be compelled to re-litigate a factual issue which has already been judicially settled. We submit that to permit the issue to be reopened would undermine not only the President's constitutional function, but the authority of the courts. Once a High Court has confirmed the lawfulness of an identification process, it is subversive of the rule of law for a different branch of government or another court not sitting as a court of appeal to second-guess the same facts under the guise of a new review. Now, we deal now with independent rationality even without res judicata. Even if this court were to disregard res judicata, we submit that the record independently confirms that the identification process complied with Zulu custom and law and statutory procedure. The President had before him a coherent, evidence-based identification process, which includes, amongst others, minutes of the royal family meetings of the 14th of May and 29th September 2021, where King Msuzulu was identified in accordance with custom. And this is to be found in volume 2, pages 360 to page 364 of volume 2 of the record. That's the Zulu version.
I must warn you now, Mr. Morana, that 20 minutes of the minutes is up now. You may start experts, especially members of
Yes, I appreciate that, Justice, yes. And page 365, still volume 2, 365 to 372 in the English version, and volume 6, pages 1116 to 1122, the English version. A resolution of the royal family meeting on 29th of September 2021, which reaffirmed the 14th May 2021 decision and clarified its consistency with custom. This is to be found in volume 4, page 735 to 736.
But what about the contention that those that were there in that meeting of the 14th of May were not members, were family. Some key members of the royal family were not invited to this meeting. That's a convention that is.
Justice Zondi, there are those allegations, but we.
Well, we know for a fact that Princess Tammy was invited.
She declined, yes.
And Prince Munisi was invited. About 3 people.
Yes. Not only that, Justice Zondi, but one of the litigants in this court, firstly, was aware of the meeting. That I'm referring to Prince Simagate. He wrote a letter and asked that that letter be read at that meeting. He knew that this was a meeting at which the successor to the deceased king was to be identified. He knew that. And he says that in the letter.
But Mr. Moran, there seem to be various interpretations of that letter.
Yes.
And they're there in the record. That's one of the problems. I think there are 2 or 3 interpretations of that letter in the record. One interpretation, he says, I'm not interested. The other interpretation, he says, but if I am nominated, I'm interested.
Yes, but the point I'm making, at this stage, Justice Nichols, is that he knew what the meeting was about.
Yes, certainly.
And the meeting was about choosing a successor to King Zwelithini. He knew that. There can be no doubt about that. He was invited to the meeting, but instead of attending the meeting, he decided to write a letter. And in that letter, he says, I'll paraphrase.
Let's go to, because I think it's a very critical document for the purposes of this case. Now, so well, it has been referred in various pages in the record. One can 745 where is the reference?
Yes, it's in volume 4, page 744. That is the original. The Zulu version is clear and legible. 744. Yes. Yes, it's exactly the same. Yes. Yes. In this letter, he effectively says. I kunjala stoliko. Yes, but unfortunately for those who are not conversant with the Zulu language, we'll have to toliga it. Yes. This is a very respectful letter. It's written in very respectful language. I mean, he greets the prince of Pindangeni, and he requests that the prince should read this statement publicly as it is written. As, in other words, he should read it as it's written. And then he says he hears that his name has been mentioned, that he, Smagade Jackson Zulu, wants the position of the king. He is very happy when he sees the prince on television saying himself that he, that is Prince Mr. Zulu, never said that he wants this position, and he confirms that. And he can also confirm that he has never said or told anybody that he wants this position. He hears that there are certain rumors, which indicate that there are probably certain people who wish that position for him, but there's nothing he can do about that. He wants to make clear that his aunt, the Princess Ndlovu, we know that is Tembi, together with the Prince Wasekwezi, they warned or advised us, being the children of the king, that if the monarch or the king or the great wife raises or mentions the name of any one of them, the one who has been so identified should accept. Therefore, if his name has been nominated, he would accept that nomination. And furthermore, they advised us or warned us that if any other one of us has been nominated, we should accept the position and support the one who would have been identified. As a child that is respectful and I think also humble, I emphasize that I would not go against the words of the old people, as I have mentioned above. I request or urge the Prince that when he reads the statement as it is, he should request the reporters that they should desist from keeping on phoning him about this matter, because there's nothing else that he can say apart from what he has already said. We thank you, Mageba. I'm your grandson, Prince Magade Zulu. So that's what the letter says. So it's quite clear.
But is he not sitting on the fence here to say, well, I'm going to wait an option? It seems to me that it's somebody who is, okay, I will behave, but if my name is,
Yes, yes, yes. That is so. That is so.
I'll go for it. So
That,
I'm ready.
that is so. But the point we are making is that he was aware what the purpose of the meeting was. And he was also aware of the outcome of that meeting, that in fact the person who had been chosen is at the time Prince Zulu. And in terms of his letter, he was expected to support that.
Mr. Morani, there's another interpretation of this letter on page 2826, which has slightly different nuances. Now, ngiyakwazi ukukhuluma isiZulu, kodwa angikwazi I don't know. I don't know which one to follow.
Let's see. Justice Nichols, you say this was at page 2?
2826.
2826. The court will bear with me. Volume 15. Yeah.
Look, like the other letter, it's somewhat ambiguous. It seems to state, I'm not going to go against my elders, but I think this one is more categoric in that if I'm nominated, I'll definitely accept. But it is a different translation from the one that is available on 745.
Well, I tried my best, Justice Nichols, to interpret it as I was making my submissions. In any event, the points I'm making, I've already made the point that he was aware of the purpose of the meeting. So there can be no doubt about that. Although there are now attempts to sort of distance certain parties from the purpose of the meeting and the objectives of the meeting, and also what exactly happened at that meeting.
So your point is essentially that he was aware of the meeting.
Yes.
He knew that it was going to be to identify
Yes,
the king
yes,
or the potential king,
that is so.
and he chose to stay away.
That is so. Not only stay away, but also say that whoever is chosen, our elders have told us to support that person. But now, instead of supporting that person, he subsequently wants to be king himself. So that is a factor. And responding to one of Justice Nichols' questions, they actually don't say who should have been there and was not there. And our submission is that this was a lawfully constituted meeting, and people who should have been there were there, and the purpose of the meeting was legitimate, and that meeting came with a result which should have been supported by other members of the royal family. If I can just return to my argument. We submit that the attendance registers of both meetings demonstrated that the gatherings were broadly representative of the Zulu royal family. And there was a signed confirmation from Prince Buthelezi, and this appears in volume 3, pages...
Sorry, who called that meeting? Because, who called it? The person who called it, and they have authority to do so.
Yes.
Who within the royal family, if meetings are to be held, who is responsible for calling the meeting? Because I'm not sure if there is a particular individual that has been identified that if you are going to the meeting,
yes,
so and so is responsible for doing that. And we are not going to attend any meeting that is called by somebody else other than the person that we have identified.
Yes. Well, I know Princess Tembi at some stage, in declining to attend, said she was not going to attend meetings in kitchens or something to that effect. But our submission is that since time immemorial, meetings of the royal family were called by Prince Mangosuthu Buthelezi. And he was entitled to that. And that's another finding by Justice Matondo.
So he was calling that meeting in his capacity as the Prime Minister, the British Prime Minister, in his capacity as the Prince, because he's part of the family.
Yes. And not only that, but there's a precedent. He had been calling such meetings in the past.
But he had been involved with the family for 6 decades.
That is correct. At volume 19, page 3792, the answering affidavit of Prince Buthelezi to Prince Mbonisi's application in the High Court. The heading is, I call meetings of Zulu Royal House. And paragraph 54, in terms of Zulu customs and traditions, the role of Prime Minister Undunankulu of the Zulu nation from time immemorial has always been to convene meetings of the royal family to discuss matters pertaining to the royal house, royal family, usually on the instruction of the reigning king. And in the absence of any such king, I'm entitled to call such meetings of my own accord as and when the need arises. During my tenure as Prime Minister, there has never been an instance in which a meeting of the royal family has been called by any person other than me, either doing so on my own accord or in the instruction of the reigning king.
Mr. Morani, Was there not some debate about this affidavit being struck out because it was unsigned? If you could just tell me exactly what the status of this affidavit is at present.
Well, it was not struck out. It's still very much evidence on which this court can make its findings.
Was it ever signed?
I beg you.
Was it ever signed?
Well,
It doesn't seem so.
well, in any event, it's in Justice Madondo's judgment. He confirms this fact.
It confirms what?
I beg your pardon.
I didn't hear you. I'm sorry.
I-
Justice
I-
Madondo's judgment, he confirms.
This very fact which appears that I've been reading, in other words, that Prince Mangosuthu Buthelezi was the Ndunankulu and he always called such meetings. Yes, we've got independent confirmation of that. Now, we submit that all these materials collectively satisfy the requirements of Section 8.1 of the Leadership Act, requiring identification by the royal family in accordance with custom. And also Section 8, subsection 3A of the Leadership Act, authorizing the President to act on such an identification. And we also submit that this is also consonant with the standard of rationality in the exercise of public power. We submit that on this independent basis, therefore, the President's recognition decision is legally unassailable. We further submit that it's worth stressing that the President's decision was not made hastily or on partial information. He had before him not only the record of the royal family's decision, but also the Premier's written confirmation that the royal family had met and reached consensus alongside dissenting views. The President also had before him a letter dated 5th of August 2021 from the Premier of KwaZulu-Natal, and this appears in Volume 3, page 578, 579, which confirmed that the royal family had met and nominated His Majesty King Misuzulu, and that there was a factional objection led by Princess Tembi and Prince Simagade. This letter was referred to in the minister's letter to the President dated 16 March 2022, and this appears in Volume 13, page 2568 to 2572.
Would that letter, Mr. Mwani, constitute consultation as set out in the Act? It seems to me that Section 8 requires consultation with the Minister and the Premier. And it appears to me that there is a bit of a contention that there was no consultation with the Premier.
Well, we deal with this later, but our submission is that there was consultation. The mode or the modus of consultation is not prescribed, but once the President asked the Minister to confer with the Premier, that, in our submission, is his way of consulting.
Consulting with the Premier.
I beg your pardon?
Consulting with the Premier.
Yes. Yes. Now, So we submit that the President, therefore, had the benefit of the Premier's views, and consultation did occur. Here we're concerned with substance, not form. Yes.
Well, the President had asked the Minister to consultation with the provincial government.
That is correct. That is correct. Yes. Yes. Now, we say that the President balanced this material and acted rationally in the constitutional sense. Now, in relation to res judicata, Prince Magate contends that he was neither cited nor served or heard in the application brought by Prince Mbonisi before Justice Madondo.
I'm sorry to interrupt.
Yes.
Before you deal with res judicata issue, let's deal with the identification. Prince Magate, what? He said that he was identified at the meeting that was held on the 5th of May.
Yes.
You remember the meeting on the 5th of May?
Yes, that was, we believe, a rather...
Prince Mbonisi,
yes.
well, Prince Mbonisi attended that meeting.
Yes.
The meeting of the 5th of May. But
Yes.
Prince Mbonisi denies that Prince Smart was identified. What do you make of it?
Well, firstly, we submit that was a clandestine meeting. It was not a properly constituted meeting, and secondly, whether or not Prince Simagate was identified, there is a letter here dated the 11th of May. Yes. Prince Simagate sort of gives the lie to that version in the letter that he wrote. The letter of the 11th of May, that was read out, which he said should be read out. It will recall that it's a lie, that I want this position. It sort of gives a lie to what happened on the 5th of May.
So you're saying that on the 14th of May, his letter should have said, I've also been nominated.
Yes.
Okay. You may proceed with your res judicata.
As the court pleases. Then he, that's this Prince Smagate, says, no relief was sought against him and the judgment was handed down without his knowledge or participation. Therefore, any factual findings made in that judgment cannot bind him under the doctrine of res judicata or issues estoppel. He also argues that the High Court erred in finding that Justice Madondo's judgment precluded his claim because the requirements of res judicata, especially the requirement of the matter being between the same parties, was not met, and he frames the reliance on res judicata as a violation of his right to be heard and to have his claim considered on the merits. We submit that res judicata applies also through issue estoppel, even where the parties are different, provided the same factual or legal issue is being re-litigated. And for this submission, as I've indicated to the court, we rely on Smith versus Porritt, which provides that the test is whether the same issue was finally decided, not whether the parties are strictly the same.
On that score, can you go to McDonald AJP's judgment and see how he identified the issues? There were 3 cases before him.
Yes.
Is that so?
Yes. Which particular paragraph, Justice?
I just want to, you're right. We have already referred to his judgment at page 127 of the record. The first matter that he dealt with, he addressed is Queen Sibongi Wilfred Zulu. And then that is paragraph 128.
Paragraph
Volume
128. Paragraph 128.
Yes. Then he deals, he identifies the issue.
Paragraph 128.
Page 128.
Page 1, yes.
He started with the matter between Queen Sibongi Wilfred Zulu and Queen Bushemata. This was Queen Bushemata.
Yes.
All right. Then he identified the issues at page 135, paragraph 23, 135.
Yes.
So it would seem to me that it was not necessary for him to deal with the identification issue in order to arrive at a decision relating to the matter between Queen Sibongi Zulu and Queen Bushema. So he doesn't say the issue here is about it's whether Prince Zulu was correctly identified. Let's go to, and then he deals with the second matter, page the second matter, the princess's application, Princess Zulu, is page 142. And then there, at 146, page 146, he identifies the issues. He says number B, paragraph 56, number B. He says whether the applicant princesses are entitled to stay in the process leading to the identification, nomination, recognition, coronation of Prince Zulu. So he does identify the identification issue here.
Yes.
The identification as an issue for the purpose of determining
Yes.
the claims of the princesses here.
That is so. That is
Then
so.
let's go to the third case, which the third matter was before him. The third matter that was before him, it's a matter between Prince Mbonisi Begikamba Zulu and Prince Zulu.
Yes.
Okay, that's a third case.
That is so.
Then let's go to page 153, where he identifies the issues.
Yes.
Paragraph 78, he identifies the issues. Number C, he says the issues whether Prince Zulu was legitimately and appropriately identified and nominated as the successor to the late deceased.
Yes.
So at least in two of the matters that were before him,
Yes.
the issue of identification was squarely before him, and
Precisely.
he had to decide that issue in order to arrive at his conclusion.
Absolutely.
Okay.
Absolutely. Yes.
So, to that extent, one will argue that it was not necessary for a subsequent court to revisit the issue because
Yeah.
it's an issue that was addressed by Madondo AJP
Yes.
in two of the matters that were before him.
That is so. That is so.
But what about the fact that Prince Simagati says, well, I was not part of the proceedings in those matters?
Well, he might not have been part, but he signed a confirmatory affidavit.
I was looking for that confirmatory affidavit.
I beg your pardon.
Did he sign a confirmatory affidavit?
Yes.
Because that
Yeah.
is what Josh Davis said in his statement, that he had signed, but there was no reference to the relevant thing.
We'll find the reference.
Nothing else will help you. Okay.
Yes, yes, yes,
Proceed.
yes.
Mr. Moran, the difficulty I have with Judge Davis's judgment is at paragraph 36, he states, I therefore find that the plea of res judicata raised on behalf of the respondents is good and it's not open for this court to overturn the judgment
Yes,
of Madondo OJP.
yes,
But his order seems to indicate the exact opposite.
precisely. Precisely. That is a problem we have with the judgment, with the inconsistent treatment of the identification. Yes, yes. As a matter of fact, Justice Nichols, we say that is the Achilles heel of the judgment. With regard to the issue that was raised as to whether or not Prince Smagatis signed a conference, volume 20, page 3871. Yes. Yes. Yeah, he says, I'm a major male, and he gives his identity number, and I'm related to the late Zulu, His Majesty, and as such, I'm a beneficiary to his last will and testament, which is a subject matter in this application, and a member of the royal family. I've read the founding affidavit, etc., and I've seen the report of the handwriting expert, which concludes that the signature on the aforesaid will is not that. I fully support the relief sought in Part A of the Notice of Motion as amended. To that end, I consent to the orders break. So he did sign a confirmatory.
So what page are you reading from, Moran?
I beg your pardon?
3871. Okay.
Yes. Yes, 3871. Yes. Well, we submit that Prince Magate had an interest and opportunity to intervene as he was aware of the dispute and the litigation, and as I say, he even signed a confirmatory affidavit. If he had a legitimate claim, he could and should have applied to intervene, and we further submit that Prince Simagati was indirectly represented, even if not formally cited. His interests were aligned with the anti-recognition faction led by Prince Mbonisi. The litigation raised the same core challenges now being pursued by Prince Simagati. And the finding on the lawfulness of the identification process, we submit, was central to the disposition of the interim relief. It's not merely academic. Well, regardless of whether Prince Simagati views the judgment as binding, the President was entitled to rely on the judgment as binding and in force. We refer in this regard to the matter of Koti versus the registrar, to the effect that decisions not under appeal or interdict are operative and they may be acted upon. It is also true that the Constitutional Court in Mulaudzi has recognized that the res judicata principle can be relaxed in circumstances where the relaxation of the principle may be done, in rare and exceptional circumstances where there is no alternative effective remedy. However, we submit that Simagati was not without a remedy. He hasn't told the court that the rescission did not apply. And if Prince Simagati believed that the judgment of Justice Madondo was handed down in error or without procedural fairness, he could have sought a rescission under Rule 42.1 or common law rescission principles. He did not pursue this route, and he cannot bypass that by launching a collateral review and ignore.
Could he have challenged that? Well, could he have been able to seek rescission under Rule 42 in view of the fact that he was not a part of the judgment?
Yes. I mean, if a judgment is arrived at in error, for instance, etc., and he's able to establish an interest, see no reason why he couldn't.
On the assumption that he had applied for intervention.
I beg your pardon?
On the assumption that he would have applied for intervention.
Yes.
Not leave from the court to intervene.
Yes, that was one of the things which he could have done.
Okay.
Yes. Now, the next heading is that the recognition decision was lawful. We submit that the President acted within the four corners of the law and in strict compliance with Section 8, subsection 3 of the Act. And that decision was informed by, firstly, the resolution of the royal family from its 14 May decision and 29 September meetings, and the authoritative judgment of Justice Madondo. And we submit that the President had no discretion under Section 8, subsection 4 of the Act, because no proper allegation, we submit, or dispute had been lodged. We submit that the section is not properly triggered. And we submit that the President, Justice Patwane, consulted with the minister as required and recognized King Mr. Zulu only after the High Court had confirmed the validity of the identification. He thus acted consistently with both the law and custom.
But do you accept that Prince Simagati could not have brought a review of the President's decision until the President actually made a decision.
Yes. That is the President's decision. That is correct. That is correct. But if he wanted to upset Justice Madondo's decision, then he could have pursued a different route. Now, we submit that the...
Can you just go to, I think that you need to interrogate section 8.4 of the leadership act, which imposes an obligation on the President that if there is evidence and allegation that the identification of the person as a king was not done in terms of the customary law and custom, then he must.
Yes.
Okay. We are not under section 59
No.
in the dispute.
No.
Where evidence
Yes.
must be used.
Yes.
But it's an allegation here. What kind of an allegation would be sufficient for the President, would be sufficient to enable the President to refer the issue for discussion?
Well, firstly, Justice Zondi, it has to be a bona fide allegation, and there has to be evidence. In other words, it shouldn't be a frivolous.
This just came being whose letter of the 3rd of June 2021, which addressed to the President, and
Yes.
she explained in great detail what had happened.
Yes. Yes. That is so, Justice Zondi. And Justice Madondo actually deals comprehensively, we submit, with that particular objection or complaint. And this is at paragraph 101 of the judgment. And we are also relying on a decided case,
Paragraph
101.
yes.
I think it bears an analysis, Justice.
Well, I see it's 11:05. 7 minutes past 11 now.
Yes.
Should we take an adjournment now until 25 past?
Yes. As a
Court
court,
will adjourn until 25 past 11.
as a court, please.